Hello friends, very warm welcome to my business law channel. So this will be the uh, second video regarding mode of dissolution of LLP or winding up of LLP. First mode, friends, I have already discussed in the last video, which was regarding voluntary liquidation. And today in this video, I'm going to take up the second mode. So under this IBC 2016, all the provisions relating to revival of LLP and also the liquidation of LLP, I will discuss. So let us begin now. The code has been divided into 5 parts comprising of 255 sections and 11 schedules. Out of these, some sections have been notified by the Ministry of Corporate Affairs in order to bring clarity and a better understanding, certain regulations have also been notified by the government. So let us take up now the key highlights of this IBC 2016. So friends, there are 2 stages which I would like to discuss here. But to initiate an insolvency process for corporate debtors, the default should be at least rupees 1 lakh. And this limit of 1 lakh, it has been increased up to rupees 1 crore by the government. So there are 2 stages. The very first stage is insolvency resolution process, which is IRS. So during this stage, the financial creditors assess whether the debtor's business is viable to continue and the options for its rescue and revival. So they try their best whether the debtor's business can be revived or not. And in the second stage, if the IRP, insolvency resolution process, fails, or the financial creditors decide to wind down and distribute the assets of the debtor, so then the LLP is liquidated. So this is the second stage. So let me discuss these 2 stages now. The very first stage is IRP. IRP provides a collective mechanism to lenders to deal with the overall distressed position of a corporate debtor. The necessary ingredients for IRP are detailed under Section 30 of the Code, and the Code covers the following steps in the IRP. The very first step is, friends, commencement of the IRP. Now, who can initiate this IRP? So there are 3 parties who can initiate this IRP. First is the financial creditor, second is operational creditor, and third is corporate debtor. Now, let us know, friends, what is the meaning of each one. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Now, the second one is operational creditor. It means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Coming to the third one, which is corporate debtor. It means a corporate person who owes a debt to any person. The corporate debtor may be the LLP or the company, but here I am talking about the LLP. And second point is moratorium. The NCLT, National Company Law Tribunal, orders a moratorium on the debtor's operations for the period of the IRP. So what is moratorium? This moratorium operates as a calm period during which no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets, or termination of essential contracts can take place against the debtor. Now coming to the third point, which is appointment of RP. RP is resolution professional. The NCLT appoints an RP or IP or RP to administer the IRP. The resolution professional's primary function is to take over the management of the corporate borrower, that is a corporate debtor or the LLP in our case, and operate its business as a going concern under the broad directions of a committee of creditors, which is COC. The next point is, friends, creditors committee and revival plan. The resolution professionals, that is the RP, identifies the financial creditors and constitutes a creditor committee. Operational creditors above a certain threshold are allowed to attend meetings of the committee, but they do not have voting power. Each decision of the creditors committee requires a 75% majority vote. So each decision in the COC is taken by 75% of the majority. Decisions of the creditors committee are binding on the corporate debtor and all its creditors. The creditors committee considers proposals for the revival of the debtor and must decide whether to proceed a revival plan or liquidation within a period of 180 days. So friends, this decision has to be taken, whether they should go for revival plan or liquidation. And the period here is 180 days. Subject to one-time extension, this period can also be extended by another 90 days. So the total period is 270 days. Now friends, I would like to talk about IBBI regulations 2018. Amendments took place. So I would like to take up now are these amendments. The Insolvency and Bankruptcy Board of India has amended the rules to mandate resolution professional to appoint 2 registered valuers to determine the fair value and the liquidation value of the corporate debtor, which is LLP in our case. The RP will share these values of the companies under resolution with each member of the committee of creditors as per the amended rules. Under the revised framework, the resolution plan approved by the committee of creditors, that is the COC, should be submitted to the adjudicating authority or AA at least 15 days before the expiry of the minimum period permitted for the completion of the corporate insolvency resolution process. Till now, friends, I have talked about first stage, and now I would like to talk about the second stage, which is liquidation. Under the code, a corporate debtor may be put into liquidation in the following scenarios or in these following cases. So the first case is, friends, where a 75% majority of the creditors committee resolves to liquidate the corporate debtor at any time during the IRP. Now, moving ahead, the second point is the creditors committee does not approve a resolution plan within 180 days or which is the extended period, that is another 90 days. The NCLT rejects the resolution plan submitted to it on technical grounds. And the last one is the debtor contravenes the agreed resolution plan and an affected person makes an application to the NCLT to liquidate the corporate debtor. These are the 4 cases where the liquidation will be done. So once the NCLT passes an order of liquidation, a moratorium is imposed on the pending legal proceedings against a corporate debtor, and the assets of the debtor, including the proceeds of liquidation, vest with the liquidation estate. On the appointment of the liquidator, all powers of the partners of corporate debtor will cease and shall vest with the liquidator. So friends, now hurriedly I would like to take up this diagram which explains the various steps as per Insolvency and Bankruptcy Code. So this takes into account both the stages, that is the IRP and second is the liquidation. So first one is that where the LLP or the corporate debtor commits default in paying financial debt, or operational debt, up to rupees 1 lakh. And then I told you, friends, this amount has been increased up to rupees 1 crore. Now, who can file this application for IRP with the AA, that is Adjudicating Authority, that is NCLT. The financial creditor, that is the banks and financial institutions, then operational creditors, for example, the suppliers, and corporate debtor, that is the LLP itself. They can file an application and initiate this IRP with AA. And now if this application is accepted, then in that case, IRP is appointed. The committee of creditors, which I have talked about, is formed. And this IRP is, AP's appointment is confirmed within 7 days of the formation of COC. After this, COC has been formed, and now, memorandum is prepared, which contains the relevant information for formulating resolution plan by RP, that is resolution professional. And now this resolution plan is confirmed by the COC, and after that, it is once it has been confirmed, it is this resolution plan is approved by AA. If it is approved by AA, then the moratorium ceases and the resolution plan is implemented. And if this resolution plan is not approved by AA, then in that case, NCLT passes the order for liquidation. And now, which are the cases where the NCLT passes the order for liquidation? Friends, I have already discussed, but I would like to repeat. The very first one is on resolution of 75% majority of the COC to liquidate the corporate debtor. So 75% of the majority of the COC members, they decide that they would like to liquidate the corporate debtor. Second is on the failure of COC to follow timeline. Timeline, you all know, 180 days, which is further extended by 90 days. On rejection of the resolution plan, on technical grounds, that resolution plan has been rejected by NCLT. And the last one is on making of application by adversely affected person. That is, the person has been affected and he has made the application to NCLT that corporate debtor should be liquidated. So friends, these are the various stages. I have discussed through this diagram also IRP, and then the second stage was liquidation. So this is all about the content. Thanks a lot for watching my videos, friends. I hope you will like the content. And many viewers, they have been watching my videos. They have been asking their queries in the comment section, which have been replied by me at the earliest. So do like my videos, do subscribe to my channel if you are not subscribed yet, and do press on the bell icon to get notifications of my subsequent videos. Stay blessed always and keep smiling. We'll meet soon. Okay friends, goodbye.